This is going to be, I hope, a short lecture about a recent ABA ethics opinion related to legal fees, and which means you should be watching this video in conjunction with learning about Model Rule 1.5, which governs lawyers' legal fees and your ethical obligations. This came out in June of 2019, so it's one of the most recent at the time I'm recording this, in the first week of July 2020. So this is 13 months old, and which makes it one of the most recent ABA ethics opinions, and very tempting for to turn into a multiple choice question on the MPRE in coming years. I've said this in other videos I've done about the ABA ethics opinions, but most MPRE administrations include one or two questions about that are basically based on recent ABA ethics opinions, and because these clarify the rules. This is about fee divisions with a client's prior counsel. And so your client had a lawyer, that lawyer's gone, and now they've hired you. And so how do you divide up the fees, especially in a contingent fee case? And so the opinion is really focused on that. It's focused on contingent fees when a counsel, and we're going to call you successor counsel, from one firm replaces counsel, predecessor counsel, from another firm, not in the same firm, from another firm as counsel for the client. 1.5b and c require the successor counsel to notify the client in writing that a portion of any contingent fee earned may be paid to the predecessor counsel. In other words, this is a invisible provision, we could call it, to B and C, which is 1.5b and c are about the writing requirements for the preference for it with most fees, and the requirement for contingent fees. And so when you're taking over a case, you're going to have to inform the client as soon as you do that if it's a contingent fee case, that the previous lawyer is going to be entitled to a share of whatever contingent fees get paid. And so I'm going to go away from the slides just a moment to explain, to remind students, why are you the second lawyer on the case? Or it could be the third or fourth or fifth lawyer on the case if you have a client who likes to fire their lawyers. Well, it could be because the client got frustrated, had a falling out with their lawyer and fired their first lawyer and now has hired you. And this is going to create an awkward situation with you and the client about the fact that the lawyer that they fired, a lot of clients feel like if I fired the guy, he shouldn't get any fees. Well, that lawyer is going to be entitled to some fees because they did part of the work on the case. It could also be that the client didn't fire the lawyer. It's just that the prior lawyer was the trial lawyer and you are the appellate lawyer. And so a lot of trial lawyers don't do appeals. A lot of appellate lawyers don't like to do trials. People tend to specialize in one or the other. And so it's very easy for you to have a situation where a prior lawyer did the trial, now you're up on appeal, you win the appeal, which means now there's a big contingent fee coming in, and you're going to have to divide that between the appellate lawyer and the trial lawyer. And we could go on with examples like this, where maybe another lawyer, the first lawyer, developed a conflict of interest and had to withdraw or something like that. The successor counsel may not be able to state at the beginning of the representation the specific amount or percentage of recovery, if any, that may be owed to the predecessor counsel, unless the amount or percentage has been agreed by the client and both predecessor and successor counsel. So everyone's happy situation is that the client and both lawyers have all agreed that you guys are going to split things 50-50, even Steven, or that the trial lawyer is going to get more because that was so much more work, or the first lawyer didn't really do much, like he left the case or the representation ended after a few weeks. So maybe he did the pleadings and filed the pleadings and did a couple of responsive briefs, and then you picked up from there and did all the discovery of the trial and everything like that. And so if you've all agreed on how you're going to divide this up front, great. If not, it's going to actually be hard at the outset to even know like what you're going to win, what the ultimate verdict would be, and therefore exactly how to apportion it. And so you may not be able to tell the client up front what percentage of the fee predecessor counsel is supposed to get. ABA Opinion 47 is really focused on the successor counsel. Now, please note this is very important. You are not bound by the requirements of 1.5e, which is about lawyers who are from different firms working on a case together, either at the time of engagement or upon recovery, because 1.5e addresses situations where two lawyers from different firms are working on a case together, not situations where one lawyer is replacing another. Now, upon monetary recovery, once we have our award or we know how much has come in, the successor counsel may only disperse a portion of the overall attorney's fee to the predecessor counsel with client consent or pursuant to an order of a tribunal of competent jurisdiction. This brings us back to, if you have a court order ordering you to do something, then you're almost always going to be covered for disciplinary purposes. In other words, don't presume to just say, well, I think predecessor counsel deserves this much because they did so much work or something like that, so you cut them a check. You can't do it without the client's consent. And if the client doesn't consent, you have a problem. We're going to keep going, but always check with the client and say, by the way, I got the check from the other party and I'm going to send prior counsel his share, and make sure the client agrees. If there's a dispute as to the amount due to the predecessor counsel under 1.15e, that's a rule we haven't gotten to yet about safeguarding client funds, the disputed amount may have to remain in the client trust account until the matter is resolved. And the dispute could be that the client says, no, I don't want you to give that amount to him. Or the client may say, I want you to disperse fees to him, but the other attorney, the predecessor attorney, thinks they're entitled to way more than anyone else thinks they should get. All of those things could happen. If there's not agreement about it, once you have an amount and so forth, you're going to stick that in your IOLTA account, your trust account, and you are going to wait and let a court sort this out and decide who is entitled to what share, or the parties all reach a happy settlement. If successor counsel negotiates with predecessor counsel on the client's behalf, so the client, let's say the predecessor counsel thinks, I think I should get this amount. Your client fired them and doesn't want them to get as much. And then your client now says, I want you to negotiate with that other lawyer and see if you can work out a deal and talk them down a little bit. Now you have a little bit of a conflict of interest under 1.7. I hope you can see that. You're negotiating on behalf of a client, but ultimately, the less the other lawyer gets, the more you get. So you have a vested interest or stake. That's what we call a conflict of interest in the amount the predecessor counsel may receive, or maybe it's about the timing of paying predecessor counsel. Okay, that's the end. That's all you need to know about that model rule. That ABA ethics opinion. And if you want to pull it out, download it and read through it quickly before the MPRE, you might find that helpful.